So you should be able to like prepare,
Right.
not prepare, but like know what's going to come up.
Maria, do you mind if we get started?
No. Please
Thank you all for joining us today. My name is Trisha Tiafalo Olave, and I'm the Senior Legal Supervisor at the National Immigrant Justice Center. I supervise our VAWA Pro Bono project. I'm here with my colleague, Sylvia Wolak.
Hi, my name is Sylvia Wolak, and I am the U-Visa and VAWA Pro Bono Project Coordinator. So welcome.
So thank you all very much for being here. You have a number of materials in front of you. Our newly revised VAWA Pro Bono Manual, including the PowerPoint slides and a couple of handouts that you might find helpful when you're taking on a case. We also ask that everyone sign in if you haven't already.
There's a sign-in sheet out at the front.
At the front?
Mm-hmm.
And then you'll also find in your materials an evaluation, which we ask that you fill out and submit at the end of the training. And then in exchange, Sylvia will pass you our CLE certificate. So without further ado, we'll go ahead and get started. First of all, to give you a little bit of background about the National Immigrant Justice Center, we are a national and local advocacy organization. We do a unique combination of litigation and advocacy and direct client services. So we see a lot of clients per year. We do legal services for over 10,000 immigrants. We provide Know Your Rights presentations and outreach to the community. And then we're able to assist as many clients as we do through our large pro bono network of over 1,500 pro bono attorneys. So thank you to all of you, because without your assistance, we would not be able to serve as many clients as we do. All of our clients are at or below 200% of the federal poverty guidelines. So if someone is over income, we will consult with them, but then refer them out for representation with a private attorney. Today, we are going to talk briefly about the various pro bono projects at the National Immigrant Justice Center. And then Sylvia is going to give you the lowdown on working with clients who are survivors of domestic violence. And then I'm going to talk a little bit about a very broad overview of family-based immigration, because that will help you then understand more specifics of VAWA, the Violence Against Women Act. So we'll go into that. And then Sylvia is going to go through preparing a VAWA case, and then the case processing and references that we have. Okay? There is no designated break in this training. We wanted to get you out in an hour and a half, which meant we didn't schedule a break, so please leave as you need to, and we'll take questions as we go. And then if there are more questions at the end, that's fine. So, NIJC offers a variety of pro bono opportunities. As you know, because you're here today, we do VAWA and U-Visa work. We have a large VAWA and U-Visa pro bono project. We also do asylum cases. We have a large asylum pro bono project. We have pro bono cases for clients who are detained and for litigation. And then we also do clinics for DACA, which is Deferred Action for Childhood Arrivals, and for naturalization, and then refugee and asylee, post-asylee benefits clinics. And then finally, for our children's project, we do some SIJ work, special immigrant juvenile work, through our pro bono project. So our pro bono projects work through a lot of coordination between the coordinators and the pro bono attorneys. The client comes in, and we determine that they are eligible for a form of relief and make sure that their case is ready to go. We conduct a thorough assessment of their case, and then once we accept the case, we sign a retainer with the client and make sure that it is ready to be passed on to a pro bono attorney. Once an attorney accepts the case, we do remain of counsel. So we keep a file in our office. So we ask that you communicate with us about any updates on the case. We also provide technical assistance. So if you have any questions throughout the life of the case, we're here to answer your questions. And then at the conclusion of the case, we will close it out, and we can walk you through every step of that. NIJC provides the outreach to the community for the clients. We do the intakes of the clients. And then once we've taken on the case, we create a case referral packet. So if you are ready to take on a case, you'll be coordinating with Sylvia, and she'll send you that case referral packet. Then you'll go through the packet and make sure that there's no conflicts. So you'll do a conflicts check and schedule your first client meeting. We generally recommend that you schedule that first client meeting. You contact the client within the first week or so and schedule that first meeting within the first few weeks. And it generally takes a few weeks to months to prepare the case. And we ask that you file it within 8 to 12 weeks if possible. Now, obviously, sometimes there are exceptions, so just communicate with us and the client if things come up. We will be there throughout the ride of the case for any technical support that you need. We also provide a review of the complete case. So once you're ready to file it, we'll take a look at it, go through it, and provide any tips or suggestions before it's filed. Through our pro bono project, we also provide malpractice insurance and policy updates as we remain of counsel on the case. Okay? Now, throughout these cases, when we sign a retainer with a client, we go through the retainer with the client and make sure that they understand their responsibilities too. So we make sure that they're being honest with us or tell them that that's necessary for their case, and that they have open communication with their pro bono attorney. So once the case is assigned to you as a pro bono attorney, we will ask the client to communicate directly with you. We will then notify you of anything that we learn through the client otherwise. So that's a general overview of our pro bono projects. I'm going to turn it over to Sylvia.
Okay, so I'm just going to talk about what it's like to work with survivors of domestic violence and things that are particularly important to consider and remember. Some of our attorneys do direct client work in their day-to-day life. Other volunteer attorneys don't. And there are a lot of things to think about and to really make sure that you're aware of when working with a survivor of domestic violence. First of all, Tricia mentioned that all of our clients are at or below 200% of the federal poverty guidelines. So they're already facing a number of hardships, potentially economically. When they find themselves in a situation where they're a victim of violence, they may face further barriers. So if they already didn't have access to a lot of money, they may not have had access to getting legal counsel. They may be facing language limitations on top of that. Their abuser might have been isolating them, both economically as well as personally. They may be part of close-knit communities that have certain cultural ideas of abuse. And so some of our clients have gotten out of their abusive situations. Some of them very recently may have been to a domestic violence shelter. So they may be processing all of these things, and they may be coming up against all of these barriers fairly recently. And these are things that may be at the forefront of their mind as they work with you. So it's important to understand what's happening in the life of the client and sort of, what things may be coming up for them. There are a number of things to consider when talking to your client, when working with your client, specifically domestic violence tactics that abusers may have been employing against them for a long time. And what's helpful here is to think about this in terms of a power and control wheel or cycle. And so, especially if an abuser does have immigration status, which is the case for all of our cases, they have citizenship or residency privilege. That means they may be threatening the abused individual by saying, "I'll take away the children and call immigration on you. I'm a citizen, you have no rights." They may be saying that you have no access to power, you have no access to attorneys, you have no access to any of these remedies because I'm a citizen, I'm a legal permanent resident, these are for me and not for you. So there are a lot of things that they may have been misinformed about. Other tactics that we maybe commonly think of are emotional abuse or sexual abuse or physical abuse. But some other things to remember and think about are economic abuse, for example. So if a person that's in an abusive situation doesn't have a bank account or doesn't have a way to access funds to escape the abusive situation, to seek shelter, to seek legal resources, that may be something that's ongoing in their life. The economic abuse can be significant in a situation like that, and it's important to ask. Especially for things like the affidavit, not just the typical questions about physical and sexual abuse, but also other forms of control and power that the abuser may have exerted against your client. So these are just some of the examples that I mentioned. How abusers can misuse immigration privilege. So specifically, other than just the things that they may say on a day-to-day basis, they may be withholding the power to actually file a family petition. And so filing an I-130 family-based petition is the first step to legalizing someone's status. They may be using that as a form of control and saying, I'll file this as long as you don't tell anyone that I've hurt you or that I've hit you or that we are in this situation. Or they may have already filed a petition or an application and threaten to withdraw it if the person comes forward about the abuse. They may also try and provide immigration officials with false information, whether that's against the client, or they may be threatening the client's family members. So there are a lot of things to consider in the sort of overall relationship of the person that's actually suffering the abuse, their family members, all these different things that are going on, especially when the individual has this very important privilege in the immigration system. Another way to think about and understand what your client may be going through is to think about what a cycle of abuse looks like. And we do have both the power and control wheel and the cycle of abuse wheel in our manual, and it may be helpful to use it when talking to your clients or trying to get information for an affidavit, because we find that oftentimes the cycle of abuse follows a certain pattern. Maybe at first there's a honeymoon phase where the abuser makes a lot of promises, is sort of courting the client. And then there's a tension building phase, maybe not overt and outright physical violence or sexual violence, but maybe it's those threats, or maybe it's that economic abuse. So something like saying, you don't need a bank account, I'll take care of all the money, you don't have to know where the money is going. So there's this tension building phase where the relationship is experiencing these tense moments. And then finally, there may be a period of explosion where there is that extreme physical violence, sexual violence. Maybe the police are called. And then oftentimes we'll see that this cycles right back to the honeymoon phase. The abuser apologizes, that makes promises, maybe files a petition that they hadn't previously filed, and then cycles back right into the tension and the explosion. And this happens over and over and over again. And so I bring this up because it's helpful to know and think about when working with your client, and also when information gathering. So if the client focuses on one specific period of explosion, there are probably a lot of other pieces, a lot of other situations, tension building, a lot of things that can additionally impact the case and can be used as evidence in the case. So it's very rarely ever just one incident of explosion that triggers the client sort of either escaping the relationship or seeking legal counsel. So this is something that's very helpful both when working with clients and to sort of have in the back of your mind to think about when you're trying to understand what your client may have gone through. So I'm going to pass this back over to Tricia to talk about family-based immigration and what all of this means for an actual VAWA case.
Do you mind if we swap?
No, that's good.
Okay. Okay, so are any of you currently, or have you practiced any family-based immigration law? Okay, so a couple people are already familiar. This is going to be just a brief general overview, but the reason it's helpful is because VAWA, the Violence Against Women Act, the immigration provisions fall directly into the family-based immigration system, okay? So when we're talking about immigration law, we're generally referring to U.S. citizens, USC, lawful permanent residents, that would be an LPR or somebody who has a green card. An immigrant could be a number of different people. It could be an asylee, a refugee. A non-immigrant, on the other hand, is somebody who has a temporary status in the United States, such as a visitor visa or a tourist visa or a student visa. And then finally, an undocumented immigrant is somebody without lawful status. So really, for VAWA purposes, most of these clients are going to be undocumented immigrants. It would be possible also for other people like non-immigrants or asylees or refugees to apply for VAWA, but generally the clients that we typically see are undocumented. So U.S. citizens and lawful permanent residents can petition for certain family members. It's a two-step process. The first step is filing a petition, which is the I-130 petition that Sylvia already mentioned. And then the second step is applying for lawful permanent residence. So depending on who the relative is and the relationship will determine how long you have to wait between steps 1 and 2. Okay? So, for example, U.S. citizens can petition for their parents, their spouse, their children, and sons and daughters. So the distinction being that a child is someone who is unmarried and under 21, and a son or daughter is someone who is over 21, whether they're married or unmarried. And U.S. citizens can also petition for their brothers and sisters. Okay? A permanent resident, on the other hand, can only petition for a spouse and unmarried children who are under 21. Okay? So if I am applying for VAWA, and we'll get to this in a moment, but if I have children who are over 21, then the only way they could be included on my petition is if the petitioner was a U.S. citizen. Okay, so if my spouse, for example, is going to file a petition for me, he can file a petition for me as his spouse, and my children would be his stepchildren. If they are over 21, a U.S. citizen can petition for them. A permanent resident, on the other hand, cannot. Okay? Sorry. This should also list sons and daughters. Cannot petition for them if they are married, but if they are over or under 21, a permanent resident can petition for them. So there is a mistake there that it should also list sons and daughters who are unmarried that permanent residents can petition for. So you'll see the distinction here. U.S. citizens can petition for many more people than permanent residents. Okay? Permanent resident can only petition for their spouse and children who are unmarried over or under 21. So sons and daughters or children, but they have to be unmarried. So the difference then, after you figure out who is filing this petition, it's either a U.S. citizen or permanent resident, then you look at, are they considered an immediate relative, or do we have to go to the preference system? So if I go back one slide, you'll see that parents and spouse and children under 21 of a U.S. citizen are all considered immediate relatives. Okay, so you think of sort of that nuclear family. It would be the spouse, children who are unmarried and under 21, and parents are all considered immediate relatives. Anyone else is outside of what we consider to be immediate relatives. And so then we're going to look at this preference system. Okay, if you are filing a petition, so if you're a U.S. citizen and you're filing a petition for your spouse, parent, or child who's unmarried or under 21, they're an immediate relative, that means that there's a visa immediately available. So they can go from step 1 immediately to step 2 of applying for the green card. Or you can file them simultaneously if they qualify for adjustment of status. Everyone else, however, has to wait for what's called a priority date to become current. So if you file that petition today, they're going to get a priority date around the time that you file the petition. So say it's filed April 5th, 2019. That priority date is sort of like their spot in line with immigration. They have to wait for that priority date to become current before they continue on to step 2, which is applying for the green card. Okay? I don't want to get into this in too much detail because I don't want to confuse anybody, but just to give you sort of a general concept of how this works. So if you're not an immediate relative, you have to wait for that priority date to become current before you can go on to step 2. And depending on which preference category you're in, that wait can be quite long. Okay? So here's the breakdown of the different preferences in this preference system. So the first category is the unmarried sons and daughters. So those are people over 21 of a U.S. citizen. I'm going to skip the second category for a moment. We're going to go to the third category. Those are the married sons and daughters of a U.S. citizen. And the fourth category are the siblings of a U.S. citizen. The second category are the people that a permanent resident or green card holder can petition for. So 2A is the spouse and minor unmarried children who are under 21. 2B is the unmarried sons and daughters who are over 21. Okay? So there you see the second group, 2A and 2B, are the only people that the permanent resident can petition for. The U.S. citizen can petition for the immediate relatives who are not on this chart, and then everybody in category for 1, 3, and 4. And then this is what's called the Visa Bulletin. So this is the current Visa Bulletin for April of 2019. So you can see here, if we go back one slide, if you're petitioning for somebody in that first category, so I'm petitioning for my son or daughter who's over 21 and unmarried, they're in the first category. If, however, they get married, then they move to that third preference category. So in the Visa Bulletin, there are separate columns for India, Mexico, China, and the Philippines because of the number of immigrants that we have here from those countries. Everyone else is in this other column. So if my relative is not from one of those 4 countries, we're going to look at that first column, okay? If my child is over 21 and unmarried, we're looking at F1, the family preference category 1. So currently, immigration is processing cases from December 1 of 2011. So that gives you an idea that the wait is probably going to be about 7 to 8 years. Now, we can't guarantee how long it will be, but that's an estimate. If my son or daughter, who's over 21, decides to get married while they're waiting those 7 or 8 years, then they move to that third category. And then that means immigration is only processing cases from September 22nd of 2006 in that category. So now that wait is more like 12 years, 12 to 13 years. Okay? So even though it might not seem fair, many people will avoid getting married or, get married or not get married based on these preference categories because of the long wait times. And then you can also see if you are petitioning for your sibling from the Philippines, for example, that's going to be that F4 category from the Philippines. Those cases are barely at June of 1996. So that's a really long time, right? Talking 20 years. So to give you an idea, when somebody says, why can't you just come legally? Well, this is why. I mean, maybe people can, but it maybe will take them over 20 years. And not everybody has somebody that can petition for them, right? So once you've figured out who's going to file the petition, what preference category they're in, how long until their priority date is current, if they are, now they have a priority date that's current, or if they were an immediate relative and a visa is immediately available for them, then we look at step 2 in applying for the green card. Now, if somebody is eligible to apply for the green card here in the United States, that is called adjustment of status. If they are not eligible for adjustment of status, then they have to consular process in their home country, okay? So briefly, adjustment of status means that an individual has an approved visa petition, so that's that first step, a current priority date, and they qualify to adjust their status to a legal permanent resident, and they have to be what's called admissible, okay? So later we will get into the various inadmissibility grounds that could prevent somebody from being eligible for adjustment of status. But the good thing for VAWA cases is if somebody entered the country without inspection, that is generally a ground of inadmissibility that would prevent somebody from going forward on adjustment of status. That, for VAWA purposes, will not preclude somebody from going forward on VAWA, okay? So you might come across a case that we're referring to you, and maybe the client entered without inspection. That does not prevent them from going forward with VAWA. Any questions so far? Yes.
Okay. So if the person has filed a I-130 and is already approved, right, in the F2A category, let's say green card category, and then they change their status to a citizen, do they have a duty to inform USCIS that they became a citizen, or can they just leave? Because the priority date, if they're unmarried above the age of 21, is weird because it's faster.
Right.
For
So let's go back to the chart. So the example you're giving is a permanent resident petitioning for whom?
For his child.
His child who's unmarried and under 21.
Was unmarried above the age of 21.
Above 21. So they would be in that 2B category.
Right. And then he naturalizes.
And then his child is over 21 but unmarried, so they move to the first preference category, right? So we're talking about going from
I think F2B.
F2B
Right.
to the F1, right? I see what you're saying. So it's not necessarily helpful.
Right.
That's interesting because usually it is.
Right.
There is an opt-out provision. I don't have the regulation off the top of my head, but generally, if it's not to your advantage, then you can opt out of that. But there has been some case law on it, so I'd have to look into it.
That's awesome. So potentially you could opt out.
Potentially, yes. Yeah, we'd have to look into it.
And then my other question is that once, say you did get your approval on your I-130 and the situation changed, the unmarried child becomes a married child, you know, you're a U.S. citizen, and they come to F3, do they go all the way in the back of the line? Or does it basically the approval date?
Because they got married?
Yeah.
No. So as long as they're still eligible.
Right.
So for example, a scenario where if you're a permanent resident and you're petitioning for your child and then they get married, they would no longer be eligible, right? So in that scenario, once that child or son or daughter gets married, they're basically giving up their petition. But for a child or son or daughter of a U.S. citizen, they just move to the new category. They don't have to start over.
But like in terms of the date,
the priority date sticks with them.
Perfect.
Yeah.
Perfect.
Yeah.
Thank you.
Sure. Good questions. Other? Yes.
Maybe this is a simple question. If they get married and divorced, does it mean they're still unmarried?
That's a good question. So it, as long as they maintained their eligibility, so if the petitioning parent was a U.S. citizen, there is a category for them when they're married, right? And so they would have moved to the third category, and then when they get divorced, they move back down to the first category. That's fine. If the petitioning parent is a permanent resident, once they got married, they lost their petition, right? So getting divorced, they would have to refile.
The application
Yeah. Yeah.
for the permanent resident.
Right. Yeah.
Can people with conditional LPR status petition for others?
They can. So generally, a conditional resident, right, they're still residents. So the only people they would be able to petition for would be their spouse, which is who they got their status from, so they wouldn't be petitioning for that person, or their children who are unmarried, and probably, in an ideal world, the person who petitioned for the conditional resident should have petitioned for their children. So,
what if you get divorced but you have conditional residency?
So that's a separate, but you can apply to remove your conditions based on divorce or VAWA if you are a battered spouse. Yeah. Good questions, Emily.
There's a time limit on that, though.
Yes.
Once you're conditional,
Correct.
remove the conditions.
Yes. So there's, when you're given conditional residency, it's for 2 years, and you need to file that I-751 within the 90 days preceding the expiration of your conditional residency, except if you're filing a waiver, and so you're not filing it jointly, the waiver can be filed at any time. So it can be filed before or after those 90 days, but the problem is if you don't file it by the expiration of your conditional residency, you will be placed in removal proceedings. So in order to avoid that, it's recommended that you file the waiver before your conditional residency expires. But that's separate. We don't want to get into too much of that. I see. We can talk more later if you have questions. Okay. So step 2 in filing for the adjustment of status, we already talked about that. Now I'm going to go into VAWA, unless there are more questions on general immigration. Okay. So the Violence Against Women Act was passed back in 1994 as part of a larger crime bill to help address domestic violence. It's been amended many times. In fact, it just passed the House yesterday, and hopefully now we'll go through the Senate for reauthorization. The law still exists, and people can still continue to apply under VAWA. These reauthorizations and amendments have actually improved the law since 1994. So under VAWA, the Violence Against Women Act, it's not limited to women, okay? It can be men, women, children can apply for immigration relief under VAWA. Who is eligible? Various categories of people. So most commonly would be abused spouses of U.S. citizens or permanent residents. Also, non-abused spouses can apply If the children have been abused, abused children can apply. Abused children of U.S. citizens or permanent residents may actually file up until age 25. So generally speaking, in immigration law, you're considered a child under age 21. This exception was carved out because many children just didn't know about their eligibility. So as long as you can explain that the abuse was a central reason for the delay in filing, you can apply up till age 25. Abused intended spouses can also file for VAWA. That would be somebody who, for all intents and purposes, believes that they are married to this U.S. citizen or permanent resident, and then discovers that the marriage wasn't valid, but not for their own fault, right? So it's possible, for example, that the abusive spouse was already married in the home country or married here and did not disclose that information. If, on the other hand, the marriage is bigamous because the victim got married twice, that doesn't count, okay? So if your client is married to more than one person at the same time through her own fault, she's not eligible for VAWA. And then abused parents of U.S. citizens can also file for VAWA. Question?
In terms of the abused children, what would separate that from them petitioning for the special immigrant juvenile status?
Good question. So special immigrant juvenile status is abuse, abandonment, or neglect by one or more parents, and that does not necessarily have to be a parent who has immigration status. For VAWA purposes, it has to fit into that general family-based immigration law, right? So the parent must have U.S. citizenship or permanent residence in order, or in this case, the abuser must be a U.S. citizen or permanent resident in order to file for VAWA.
Okay. So if their parent had status, we'd be, that's probably a VAWA.
Mm-hmm.
And if they didn't, then we'd probably refer them to SIJ.
And then the other thing would be that SIJ requires usually a predicate order under state law, and the child usually has to have that before they're 18.
Yeah.
So if somebody comes to us and they're already 18, VAWA, and they're eligible for VAWA, that would be a good option. Okay, so the Self Petitioner, yes, go ahead.
Is there, in terms of whether a marriage is entered in good faith, is there any examination or analysis done as to the components of the validity of the marriage? So that is to say, what if they're coming from a cultural context in which something is understood as marriage, but would legally within that country and within our country's laws would not necessarily constitute a formal marriage in the sense of there's it's legally registered as a marriage, but the person believed that they were in a good faith marriage because it's sort of that cultural understanding of the
So, are you referring to a customary marriage in Africa, for example?
Sure, yeah, something like that. Yeah.
So, if they can prove that it was a legal marriage, then it's fine. And we're going to get to this in a moment, so just hold on to that. But generally, it has to be legal in the jurisdiction where the marriage took place. Yeah. So, the first thing that we're going to look at with VAWA is the Self Petitioner. How do you prove these various elements of eligibility, and what are they, right? So first you have to prove the status of the abuser. Then you're going to have to prove the marriage requirements, which includes the good faith of the marriage and that it was a legal marriage, battery or extreme cruelty, and then there are certain residency requirements that you have lived together, and good moral character. Now, the good moral character period for VAWA is 3 years preceding the date of filing. So, when we look at these elements separately, if we're looking at a marriage, to Gerald's question, it has to be a legal marriage, valid in the jurisdiction where it was performed or celebrated. The exception would be if it violates public policy here. So, for example, if it is a bigamous marriage in another country and that's valid there, but it's not valid here, then that person won't be eligible, right? But if it was the first marriage there, and then they are eligible for VAWA here. Does that make sense?
Does the United States, I know that we have DOMA and whatnot, but does the United States recognize oral marriages without a wedding license?
Oh, sure. So it depends on the law in the place where it took place. So, for example, sometimes you can have marriage by proxy in some jurisdictions, right, where somebody else can stand in for that person. So if they aren't physically there, but it would depend if that location, that jurisdiction allows for that or not.
Illinois doesn't, I believe. Right?
Well, so generally you'd be talking about, I thought you were referring to abroad.
No. So in the United States, so what's happening in my community is that, we have, multiple marriages are not uncommon.
Yeah.
From my client's home country,
Sure.
for example. So my constituents that I work with, there've been often times where the victim, she's not really a spouse if you think about it, because a clergy or a rabbi or something just blessed the marriage, but there was nothing written.
It was not legal.
It was not. So
I see what you're saying. So, yeah, you have to look at the law of the jurisdiction because, for example, in Mexico, if you have a religious ceremony, that does not qualify as a legal marriage. But if you have the civil ceremony, it does.
Right.
Whereas here, if you have a religious ceremony, that can count for a legal marriage because the officiant registers the marriage the same as if you were at City Hall.
So if there was no registry done, then
Right.
there's no marriage.
Then there's no marriage.
Perfect.
And as far as you mentioned DOMA, so same-sex marriage is legal federally, so any same-sex marriage that is a legal marriage would also be eligible for VAWA. And I mentioned intended spouses already, so that would be the bigamous situation where the victim believed that it was a real marriage. So all of those would be considered valid for purposes of VAWA. And you have to prove that the primary purpose for the marriage was not to circumvent immigration laws, right? So if immigration believes that you married just to get your immigration status, they are going to deny your case. Now, throughout the years, as there's been various reauthorizations of VAWA, they have amended VAWA to include some exceptions. If the abuser has died, then the petitioner can still file if that abuser was a U.S. citizen. Okay? If the abuser and the VAWA petitioner are divorced, you are eligible to apply for VAWA within 2 years of the date that the divorce is final. But the VAWA self-petitioner cannot remarry before filing the VAWA petition. Okay? And then if the abuser has been deported due to the domestic violence, then the victim can apply for VAWA within 2 years of that deportation. Okay? So, yes.
I have a question. Sorry, going
Sure.
back to the marriage instances. You said that they're going to deny the application if the marriage was to circumvent immigration laws. You said that you have to prove that it's... So the burden of proof is on the applicant to prove that the marriage is, rather than the other way around.
Right. That is an interesting predicament, right? You would think if you have a valid marriage certificate that would be enough. But generally what we recommend, and I'll get into this, or actually Sylvia will, with documentation, but various types of documents to prove the good faith marriage. Okay, so we have a lot of suggestions, and we'll generally go through all of this with the client before the case comes to you. But that is one of the requirements of VAWA, is to prove that it was a good faith marriage at the inception, right? So that, for some cases, might be very simple. Maybe they had children together and they've been together for 20 years, and then there was abuse and then they separated. For some, it was an arranged marriage, and the first night that they met, there was abuse, and that was it, right? And so sometimes it's trickier, but it's definitely possible because of the standard of proof that we have to meet, and we'll talk about that too. But yeah, it's unfortunately the burden is on the petitioner. So once we get to the battery and extreme cruelty, the definition is actually found in the Code of Federal Regulations, and it's broadly defined: an act or threatened act of violence, including any forceful detention, which results or threatens to result in physical or mental injury. Okay, so that's pretty broad. Other abusive actions may also be acts of violence under certain circumstances, including acts that, in and of themselves, may not initially appear violent, but that are part of an overall pattern of violence. And that's important because, as Sylvia mentioned, in working with victims of domestic violence, oftentimes it's not one incident that's going to draw somebody into our office. Or, there are many clients who don't really even recognize themselves to be victims of domestic violence until they're meeting with a therapist, or until somebody explains that this is not, they don't need to be experiencing this, right? And so it doesn't have to be one specific incident. It can be the totality of the circumstances. Finally, good moral character is also an element that needs to be proven, and they must establish good moral character for the 3 years preceding the filing of the petition. They have to have no bars to good moral character under INA Section 101F. And there is an exception to that at INA Section 204A1C, specific to VAWA, that it can waive an act or conviction that's connected to the abuse for purposes of admissibility or deportability. Yes?
So in order to prove the good moral character, are you guys suggesting like maybe an FBI report, background report, a rap sheet, or a rap sheet from the police department?
Usually what we recommend is that clients go get a police clearance letter from every jurisdiction where they've lived for 6 months or more during the past 3 years.
So the only issue is my clients that it seems like they're extremely scared to walk
to go to
in
the police station.
That is the big no-no. Like,
right.
That is, and as I'm trying to refer them to NIJC,
yeah,
that was the biggest problem.
So there are different ways around it. Some law enforcement agencies, we know that they're not going to refer somebody in immigration, right? So we can tell the client, you should be safe going here. For others, we would maybe recommend that they go with somebody, or that they ask somebody to go in their place, or sometimes these things can be requested through the mail, right? So there's a variety of ways to do it. Otherwise, maybe an Illinois State Police background check or the FBI background check, depending on the circumstances of the case. Yeah, so there's different ways you can handle that. So as I mentioned, the standard of proof for these cases is any credible evidence. So we often, in our cover letters, remind the adjudicating officer of that, because we don't want them unnecessarily requesting things that they shouldn't be requesting, right? To your question about proving the validity of the marriage and the good faith marriage, if we have the marriage certificate, we have the divorce decrees of any prior marriages that have ended in divorce, and some documentation to prove that it's a good faith marriage, that should meet this any credible evidence standard. Yeah, go ahead.
This situation you're saying is not in court, it's with the interview.
Correct. These are affirmative applications that are filed with USCIS. So actually, if your client is in removal proceedings, the judge does not have jurisdiction to review the VAWA Self Petitions. So those are adjudicated by the Vermont Service Center. So all of these petitions, the I-360 VAWA Self Petitions, are filed at the Vermont Service Center, and they have a unit that's trained in domestic violence, so they should understand these scenarios. Yeah. And then confidentiality provisions are also very important. As you mentioned, your clients who are afraid to go to the police, well, many of these clients are afraid to file these petitions because what if the abuser is going to find out, right? And then will that person retaliate? Well, fortunately, there are sections of the law in IRA that prohibit all DHS and DOJ, so Department of Homeland Security and Department of Justice employees, from providing any information about a self-petitioner to a third party. So the only way that the abusive spouse would find out is if the client tells him. Okay, so we always recommend to our clients not to tell your abuser about this. Even if you're in the midst of an argument, don't say, well, I'm going to file for VAWA, because that's probably not going to help you in any way. That same section of the law prohibits Department of Homeland Security from making any decisions about a case based solely on information provided by the abuser. So that's also important because in some circumstances, Sylvia mentioned maybe the spouse filed a petition, filed an I-130 family petition, and then threatened to withdraw that petition. Well, what I've actually seen happen is maybe the abusive spouse filed that petition, and then they get scheduled for an interview. And then he finds out, that she's filing for VAWA, or maybe he doesn't know that, but he knows that they're separated now, and she's filed police reports against him or whatever. If he shows up to that interview, the officer can't make a decision on her case based solely on information provided by him. He would have to take into consideration the self-petition. Okay, so what I've done in a scenario like that is tried to get the officer ahead of time to reschedule the interview, explaining that she is now filing for VAWA, which is possible. Or if there's just no time and you have to go to the interview, you go with your client and represent them and explain, officer, we have since, not with the abusive spouse there, but explain in private, officer, we have since filed for VAWA. We ask that you hold this case in abeyance while the Vermont Service Center is adjudicating the VAWA self-petition. And they generally will do that. Yes.
I don't know, I might be ahead, but oftentimes what happens is that the beneficiary or the victim in this situation is on the 751, basically the conditional green card.
Yeah.
The 751 has already been filed. Mm-hmm. There's this lapse.
Joint?
Between, right, joint.
Mm-hmm.
It's been filed together, but then there's this lapse between the interview and where things just, it just goes haywire. The victim comes to the office, he's, what do you do in that situation? Do you just wait for the interview to take place, or do you just do a VAWA waiver?
So that's, depending on the case, I would look at a case-by-case analysis because some spouses, after they separate, are still amicable enough to go forward with the process, and some are not, and some can't be trusted, right, either way. So you can do a couple of different things. You can either amend the I-751 to be a waiver, or you can file a new petition. I would say, though, if you have helped the couple jointly, you would be conflicted out of helping the abused spouse. So you would want to refer him or her out for assistance with that waiver. Yes?
On that note, if another attorney were to take the I-130,
yep.
And they're scheduled for an interview, at what point do you step in and who do you speak to with respect to that now the beneficiary is self-petition?
Yeah, so that's really tricky because you don't want to divulge any client confidentiality, right? You don't want the abuser to find out about the VAWA petition, and that I-130 technically belongs to the petitioner, so that would be the abusive spouse. So I would only communicate with USCIS. And then, so there's not frequently I-130 interviews unless they're with an I-45, right? Occasionally, there are interviews for I-130 petitions themselves, but generally it's for a one-stop application where there's been both an I-130 petition and an I-45 application. And so the easiest thing to do in this scenario is when the VAWA self-petitioner comes to you and says, this has already been filed, I don't know what's going to happen, right? We have our interview coming up, or we don't know when our interview is going to be scheduled. You can immediately sign a retainer and a G28 and then notify the local office and say, my client is filing for VAWA. We request that you hold this case, the I-45, in abeyance, because the I-360 takes the place of that I-130. And so that I-130 will just sort of stay until they've adjudicated the I-360. And then once that I-360 has been approved, they no longer need that I-130. So then probably once they're going forward with their VAWA adjustment, at some point an officer might request that I-130 be either withdrawn or abandoned or denied. Yeah, sure. So why would somebody want to file for VAWA? A lot of clients are scared, especially in this current climate. Well, there are many benefits. First of all, if your VAWA self-petition is approved, you get deferred action. Okay, so deferred action, although it's not a legal status, it does provide protection in that you should not be referred for removal. You can also get employment authorization with a VAWA approval, and you can include your derivatives. So if you have children who are unmarried and under 21, they can be derivatives on this petition. You can also include children who are outside the United States, and you may, after this VAWA petition is approved, you may be eligible to apply for adjustment of status. So we'll talk briefly about the adjustment of status. Not all of the cases that we have on our pro bono list are eligible for adjustment, right? So if you take a pro bono case from us, a VAWA pro bono case, we will clarify whether or not that person is filing just the I-360 VAWA self-petition or if they're filing what we would call a VAWA one-stop, which would be the I-360 petition and the adjustment of status application, this I-45. So we will assess that before the case ever gets to you. In order to file for adjustment of status, they have to be eligible under INA Section 245A. They need to have the approved VAWA self-petition. In some cases, they can file simultaneously, so they would file both the I-360 and the I-45. And they have to, if they are not an immediate relative, they have to have a current priority date, right? And the other important thing to note is that adjustment of status is discretionary. So if a client's VAWA self-petition is not a slam dunk case, or we have concerns that it might not be approved, we might recommend that the client wait to file for adjustment of status until that VAWA self-petition is approved. In order to file for adjustment of status, you need to be admissible. So inadmissibility is an immigration term, and under INA Section 212A, there's a variety of things that can make someone inadmissible to the United States. Primarily health, criminal, security, previous immigration violations, false claims to U.S. citizenship, previous removal order, and someone who's unlawfully present in the United States. So those are, generally speaking, the inadmissibility grounds that we see in our office. The public charge ground of inadmissibility no longer applies to VAWA self-petitioners. So if your client is admissible except for the fact that maybe you're concerned that they will become a public charge, which is a concern in family-based immigration, you don't have to worry about that for VAWA purposes. They don't need an affidavit of support. In fact, there's a Form I-864W, the affidavit of support exception or waiver, that they would file instead of the affidavit of support. If your client is inadmissible due to certain grounds of inadmissibility, they might be eligible for a waiver. Okay, so if we make a determination that the client is inadmissible for X, Y, or Z, but they are eligible for a waiver, we will provide that information and explain it to you. Generally, there aren't a lot of cases like this on our pro bono list, but it's important for you to know, because if you think that a client might be inadmissible for something, please let us know, right? So if the client has made a false claim to citizenship, for example, that will not prevent them from getting VAWA approved, but it will prevent them from being eligible for adjustment of status. Okay, so there are waivers available for several grounds of inadmissibility, and generally speaking, the waivers will require a showing of extreme hardship to a U.S. citizen or permanent resident, spouse, or parent, and in some cases a child. And for VAWA, sometimes you can show hardship to yourself. Okay, so there are distinct waivers only available to VAWA self-petitioners where they can prove hardship to themselves. Any questions? Yes.
I'm so sorry.
No, that's okay. The questions are good.
So you said unlawful presence. You know, you overseek the B1, B2, your tourist visa, obviously. You know,
yes.
You get to U.S. citizens, you can adjust your status. There's no need for a waiver if you're just an ordinary adjustment status, correct?
So unlawful presence is interesting because it's not triggered until you depart the United States. So if you enter the country on a lawful visa and then you overstay that visa and you begin accruing unlawful presence, you don't actually trigger the unlawful presence ground of inadmissibility until you depart the United States.
Right.
So that's a weird scenario where our laws actually encourage people to remain here undocumented, because if they leave, they're going to trigger this ground of inadmissibility.
So then we're good.
Yes.
And then my whole thing is, well, people who entered here without entering to a port of
right.
inspection, do you do the 601A provisional
so,
waiver?
So as I mentioned earlier, it might not have made sense at that point, but just entry without inspection does not prevent somebody from going forward with VAWA adjustment.
Perfect.
There's an exception under 245A for VAWA self-petitioners. So if their only ground of inadmissibility is that they entered without inspection, that's fine for VAWA.
And they can adjust within the United States.
Yes.
They don't have to get
Correct.
a advance.
Correct. They could actually file their I-45 with proof that the I-360 was approved and adjust their status here. Yeah.
Okay.
So it is actually, that's great that you reacted that way, because it's a huge benefit that a lot of people don't realize. I mean, because it seems very logical, like everybody should be able to do that, but in immigration law, everybody else can't do that, and so it is a huge benefit. Question?
Sorry, I'm new to this.
That's totally fine.
I'm struggling to think an example of a health-related grounds for inadmissibility? Is it like
Sure.
a communicable disease or?
Yes, exactly. So when you're applying for adjustment of status, one of the requirements is to get a medical exam from a civil surgeon designated by immigration. So it can't be just any doctor. It has to be somebody on immigration's list. And they'll do an exam for things like TB and, various communicable diseases and determine if the person is inadmissible. HIV is no longer a ground of inadmissibility.
So, but then you become admissible again if you...
Right. Like generally, so what we'll see sometimes is on the medical exam that the person maybe had TB but is under treatment, and that's fine. Yeah. Other questions? I know it's a lot of information, and it can be very overwhelming. I don't want you to be overwhelmed. I want you to just have a basic understanding so that when you get the case, you'll kind of remember, like, oh yeah, they're eligible because of this, this, and this. What you need to worry about is what Sylvia is going to talk about next, how to actually prepare the application. We do all this on the front end, so you don't even have to worry about it. But it's important that you understand this and that if somebody comes to you outside of the NIJC cases, you think they might be eligible for VAWA, now you know to refer them to us, and we can do a thorough assessment. Okay? So, Sylvia, back to you.
All right.
So I'm going to spend some time talking about preparing a VAWA case, and please note there is a lot of information in this section. I'm not necessarily going to go through all of it in extensive detail, but hopefully it can be a great reference for you as you work on a VAWA case, as you prepare a VAWA case. So it's fairly comprehensive. The things that I am going to talk about are interviewing your client, evidence, so the kind of evidence that you'll want to include in your VAWA case, things like the affidavit, biographic information, proof of abuser status, good faith marriage, which is something we've already talked about, joint residence, current residence in the U.S., good moral character, and battery or extreme cruelty. So that's just sort of the breakdown and the layout of the types of evidence you may want to prepare. Of course, not everything is going to apply to everyone in terms of the documents that people can gather, and I'll talk about that as well. So the first thing to think about when interviewing your client, I would say is to think about the client's safety. Definitely do a safety check. Most of our clients, or many of our clients, are already out of the abusive situations that they've been in, but some of them may still be being pursued or followed by their abuser. So doing a safety check, and then also building trust. And the way you build trust with an individual is to remind them that everything they're telling you is confidential. Find a volunteer interpreter if necessary, even if the person speaks English but maybe isn't feeling very comfortable in English, finding an interpreter so that you don't have any miscommunication. Referring to counseling or other services as needed. So if the client still seems to be going through a lot emotionally, having a really hard time talking about what they've been through, maybe offering some referrals, which we have. We have many referrals that we can definitely provide. Some normal things that a lot of law firms or solo practitioners do is sign a release of information and a retainer agreement. And so, we'll have already taken the case and prepared a lot of documents, or as many documents as possible for you, but you yourself may also want to go through whatever internal procedures you have as an attorney. So signing those agreements, and then also clarifying your relationship with NIJC and going through all of this information again with the client, because it is overwhelming, right? If it's overwhelming for you today, this sheer amount of information, it's certainly overwhelming for the client. And maybe we've met with them 1 or 2 times, but it's a lot for them to think about and remember. So it's always helpful to sort of give them another explanation about what the plan is, what they're eligible for, etc. Building a relationship of trust is hugely important, and so some things to think about are maybe creating a physical or emotional space that's comfortable. So definitely meeting somewhere privately, avoiding legalese, so speaking in plain terms and plain language so that the client can understand you. Maybe even checking in, right? Do you have any questions? Do you want to stop for a minute, especially if they're having a hard time talking to you, giving them a moment to rest, offer water. So just being kind of aware that this is a person that's been through some very difficult things and checking in with them and how they're doing. So for the initial meeting, really, we recommend learning the client's story, and we'll have a series of case notes that we already share with you just to give you some background. But meeting the client, hearing from them in person, you can begin filling out the application forms, make copies of documents, but things like actually getting to the details of the affidavit may be better reserved for subsequent meetings. And you can gauge how your client is feeling, but it can be very painful and very difficult for people to revisit those moments and those situations. So the initial meeting is usually for these sort of basic things, and then subsequent meetings is where you can really delve into the case, prepare the affidavit, prepare the forms, and finalize the forms. So for the affidavit is a critically important piece of the application. It provides the client the opportunity to tell the story in their own voice. Some clients prefer to create a draft. It may be in their native language, maybe they do speak English, but oftentimes that draft isn't enough. So then you, as their attorney, can help them by asking questions, by fleshing out this information, working with an interpreter to get more details, thinking about that power and control wheel, thinking about the tactics the abuser might have used, and asking questions to find out more about the situation. The domestic violence counselor, if the person is actively in therapy, can be a good resource for helping the client draft their actual affidavit. But usually you will also have to meet with the client and add information as necessary in their own words. So it has to address key issues. Basic biographic things like their applicant's name, date of birth, place of birth, entry to the United States, and any exits. Those are sort of, the nice things to start off with to build the story. And then talking about the marriage to the abuser, and exploring how they met maybe. So thinking about starting off with, what was the honeymoon phase, right? How was your relationship in the beginning? Asking big, broad questions and allowing your client to talk and take notes as they talk can often be very, very helpful. Then, of course, the names and dates of birth of children, if there are children, asking them about their joint residence for their affidavit. Where did you live together? And when you lived together in this place, how was that relationship? And then where did you move? Why did you move? You may discover that moving around a lot may have been part of the abuse. So all of these things will organically flow as you begin to delve into the client's story. And battery or extreme cruelty, all of those things can be part of any of these other pieces. So if you're asking them about their children, maybe they'll say, things got really difficult once our first child was born. We started to argue a lot. And then that'll sort of open up more questions for you to ask about battery or extreme cruelty. And finally, good moral character. So if the client does have any arrests, explaining those arrests in the affidavit. What happened? For certain situations, there will be things that are very explainable, right? So I was arrested for shoplifting because my abuser left me in the home with our baby, and I didn't have any money, and I had to get us food, and I didn't know what to do. So I went to the store and I took something, right? So that's clearly tied to the abuse, and it's something that needs to be explained in the affidavit, and it's something I've seen several times with our clients, actually. The affidavit must be accompanied by an original signature and certification of translation. You don't have to hire anyone to do this. We have sample language on our website in our manual appendices, so we have a ton of resources for you that you can use, but it does have to have an original signature, and you have to have your translator also sign it if they were translating the affidavit. So it's fairly simple, but you do have to make sure that you hit that target language for immigration to accept it. Some other things that I'll just briefly touch on, of course, you need identity documents, you need some kind of proof of the abuser's status. Now, keep in mind that if this is a person who escaped an abusive situation, they may not have a lot of documentation, hence that any credible evidence standard that Tricia brought up. So they may not have their abuser's birth certificate or passport, right? Those are things that are not attainable and not achievable, but maybe it's possible to look up the abuser's voter registration to prove that they were a U.S. citizen. So there are a lot of ways to get creative if your client doesn't have these specific documents that are listed here, like the birth certificate, the U.S. passport of the abuser, the green card, right? Those are some ideas, but there are definitely ways around this. Proof of good faith marriage. So these are more ideas of how to prove that the marriage was entered into in good faith and not just for immigration purposes. So, of course, things like the marriage certificate, but also leases in both names, maybe a bank account in both names, maybe some photographs of the wedding. And certainly there may not be a bank account, especially if economic abuse was part of the abuse. So that's something you can address in the affidavit. And then get letters signed by family and friends explaining this is what this person went through. I know because when I visited XYZ happened. So letters of support from family and friends can be critically important, especially when a client doesn't have a lot of documentation. Joint residence, same idea, maybe joint correspondence that they received at the same address. Current residence in the United States. Mail is very useful for a lot of these things. Good moral character, Tricia already mentioned, so you'll want clearance letters for anywhere they've lived for over 6 months in the past 3 years, so either from a police station or you can do something like FBI prints, depending on what kind of case it is and if it's safe to do that. Battery or extreme cruelty. The client affidavit is going to be central proof for battery and extreme cruelty. Their telling of their story is going to be extremely important. Other things that you may be able to get, and maybe we've already copied these for you if the client's been in to see us several times, are police reports, certified dispositions for the abuser's arrests, if the abuser was arrested, any orders of protection, medical records, if the client went to seek medical help for some extreme abuse where they were physically injured. But again, maybe the client has none of these things, right? Maybe they weren't able to access police assistance, or maybe they were never able to get an order of protection. The affidavit then becomes even more and more critically important, and other supplementary evidence becomes critically important in that scenario as well. So filing procedures, the sort of, where do I file? How do I file? What are some of your best practices? These are the things that you'll need in order to file a complete and comprehensive VAWA self-petition. First and foremost, a detailed and argumentative cover letter. We have a number of samples on our website. We have sample filings, sample affidavits, sample translations. So all of these things are readily available, and we're here to help you with resources and in any way that we can. But you will need a very good and comprehensive cover letter. The G28, and that's the entry of appearance form that you submit as an attorney, and then Form I-360, which Tricia has already brought up several times, which is the form for the self-petition itself. If the client is also eligible for adjustment of status, so for the green card application, you can either prepare another detailed argumentative cover letter or combine these two if you're filing simultaneously. And again, you'll need a G28 for that. You'll need Form I-485. With that Form I-485, you'll need 2 passport-style photos, the I-693 medical exam, the I-864W affidavit of support waiver, which Tricia, again, has already referenced. And there is an option for an application for a fee waiver. So the Form I-485 is quite expensive. I believe it's...
$12.25.
Thank you. I was getting to that. So it is $12.25, and that's really an insurmountable amount for a lot of our clients. So most of our clients will qualify for a fee waiver because it's just not something that they can pay. And using taxes or maybe their paycheck stubs, you can prove that they make below a certain amount, and then there are a couple other ways to qualify. So that's something I like to bring up and mention because it is quite expensive to file that. And then Form I-765 is the employment authorization form, and that also requires 2 passport-style photos. So the filing fees are here. The I-360, the actual VAWA application form, doesn't cost anything. The I-485, there are a couple different fees depending on age and some other requirements, but $12.25 is usually the standard. Form I-765 is included. The cost of it is included with the I-485 filing. But if you're only filing the I-360 and you want to include a Form I-765, that does carry a fee of $410. So depending on what you're filing at what time, those fees can vary. And all of these things will qualify for the fee waiver as long as your client is eligible. Yes?
When you're filing the I-360, say if this is an LPR situation where you're just filing the I-360, you can file for I-765 with the I-360 without the 485?
So there are different categories of employment authorization.
Right.
And so for an approved I-360, you can apply for category C31. Tricia, I don't know, is the applicant eligible once the VAWA petition is approved, or do they have to wait for the category to be current?
So they're eligible once the VAWA is approved, but not while it's pending. So
For C31.
So because they're not eligible until it's approved, you can file it with the I-360, but it might not be adjudicated, and it could be rejected. But if you wait until it's approved, then it's not an issue.
Okay, and then typically the timeline for the approval timeline?
It's a long time.
Yeah, we'll get to that in a moment.
Yeah, so the timeline for approval, if you're just filing the I-360 case, I think it's over a year right now. Yeah, it's like 16 or 18 months. It used to be under a year, but the adjudication times for all immigration cases across the board have been going up and up and up. And so what I want to clarify is the Form I-765, if you file it with Form I-360, you do have to wait until the I-360 is approved. But if you file Form I-765 simultaneously with the I-360 and the I-485, it can be based on a different category. It will be based on the pending I-485, and that employment authorization you'll actually get immediately. And so these are things to consider when filing, and we're happy to help you through that when you do take on a case, because it does get a little bit convoluted.
One more question. For derivatives, do they have to do a separate I-485 as well?
Yes. So derivatives can be derivatives on the I-360, but they need their own Form I-485, correct?
And then the I-130, the I-765 is for the I-131 also can come out to that too, right?
If you're filing for the adjustment.
Yeah. Cool.
Right. So the I-360, for the purpose of derivatives, if we're just talking derivatives, they can be derivatives of the I-360, but when we're talking about them getting their own work permit or them getting their own green card, they need their own set of separate forms. So when we say derivative, we really mean derivative on the I-360. So some filing tips. As a reminder, all foreign language documents must be accompanied by a translation that is certified. That doesn't mean it has to be, certified by an official translator. We have templates on our website that you're welcome to use, but they do have to be signed by the translator. So you don't have to go and pay someone necessarily, but you do have to have a certified translation based on what immigration requires. And again, we have a ton of templates for that. Just some general things. We recommend 2-hole punching the application packet at the top and binding it with metal prongs. Don't use any kind of spiral binding. Don't use any kind of tabs or exhibit markers that stick out. You can use exhibit stickers for your exhibits at the bottom of the pages. USCIS, we've been told, scans these files in, and so they hate having anything stick out. So none of those kinds of bindings that would prevent them from scanning the file in easily. Confirm you're using the most recent version of the form. So the most recent version of the forms can be found directly on the USCIS website. They do change every so often, and often without warning. So we may not have a lot of notice. So before you file, I always recommend just go onto the USCIS website and make sure you're still using a version of the form that they are accepting. So we recommend placing all the filing packages in one mailing envelope and using a trackable delivery service like FedEx or really anyone to prove that the case arrived on time, especially if there's any kind of deadline. So maybe if the derivative will be aging out or turning 21, just making sure you have proof of delivery for posterity. Where to file? All VAWA self-petitions and accompanying applications get sent to the Vermont Service Center, the VAWA unit, which is in Vermont. And this is the address. And then case processing. So what happens after the filing? What can you expect once your application has actually gone out and been received by immigration? The first thing you'll receive is a receipt notice. These have also been taking longer and longer. Immigration should send you a notice saying, we received this form on this and this date for each and every form that you filed. So the I-360, the I-485, the I-765. In approximately 4 to 6 weeks, we've seen them take 8 weeks or longer in recent months, but they should arrive. So make sure you get an actual receipt and confirmation from immigration. And if you don't, you may have to request one, and we can help you with that. You may also receive a Prima Facie notice, and it will look something like this. It's not an approval notice. It's a notice that essentially tells you that you have submitted all of the documents and forms required for the application. So they haven't really done any kind of review of the case, but they'll say, well, you submitted all the clearance letters you needed and all the forms you needed, and so we've determined that everything that's supposed to be submitted is submitted. We don't vouch for its merit quite yet. What's the point of it? Well, it can be used to obtain certain public benefits. So let's say your client is in a dire situation and needs some public benefits for their kids. It can be used to obtain those benefits depending on what's available in the state and, whether there's money for that. So it is sort of dependent, but it can be great for clients who really need that support. What are the outcomes of a self-petition of a potential filing? The first thing you might get is a request for evidence if immigration has additional questions about any part of the elements of the case that I've mentioned or Trisha's mentioned. So maybe they have some questions about good faith marriage. Maybe they want to know more about the abuse. So they can ask for more information, and they'll usually give you a deadline. Or they may not ask for any additional information, and they'll issue an approval. If they have serious concerns about the case, they may issue a notice of intent to deny or a denial. I don't think I've seen a notice of intent to deny since I've been on the project, and that's been 3 years, so that probably speaks well of the kinds of cases that are being prepared. But if any of these things happens, a request for evidence, an approval, a NOID, or a denial, please let us know. We'll help you through any one of these pieces. We'll help you think about what evidence you can request to respond. Once you do receive an approval, we definitely want to tell you what the next steps are, how to close out the case. We want to thank you officially in our newsletter. And we want to be able to close out the matter. Yes?
RFEs are the most annoying thing.
Sure, yeah.
Is this a norm, like when in VAWA petitions to see RFEs? Like, I mean, is this...
Is it a norm? I would say it's becoming more and more common under the current administration and different policies, whatever's going on. For example, if a client has any kind of arrest, most likely an RFE will be issued, but it's not uncommon. And unfortunately, requests for evidence are becoming more and more comprehensive, so it's really important to formulate a strong response. And we try and walk you through how to respond to requests for evidence. Oftentimes, they're also formulaic, so they're not really asking things specific to the case. They're giving you blanket language. please prove good faith marriage. And then you have to say, well, here are all the things that I already submitted to prove good faith marriage, and then here are a couple extra things. So once they do issue something, they're usually using their blanket language, and that doesn't necessarily mean that the case you submitted wasn't strong. It can mean that they're just issuing a request for evidence and they're hitting you with their standard language. Yeah, it can be very frustrating, but it's very important to respond well, and usually a strong response yields an approval. So, yeah, another question?
Yeah, from what I've seen, it's not uncommon to see clients who are trying to apply for VAWA while still living with the abuser.
Mm-hmm.
What are some practices that you've seen to keep people safe in the long run? So if they are still living with an abuser, even from the point of approval, how do you keep them safe? How do you check in with them in a way that doesn't put them in danger? All that kind of stuff. I guess, like, what are some practices that are specific to those types of situations?
That's an excellent point, and that's why I would say the safety check is critically important. Some clients will select a safe address. Either they'll get their own P.O. box or have a trusted family member or someone receive information from you as their representative or their attorney. They may have a private email address, so they may say, please never mail me anything anywhere. I don't have any safe place to have these documents, but you can send me approval notices or things via email, and I'm the only one that checks that. So asking them what their sort of safe form of contact is, definitely asking about phone calls. So can I call you directly on this number and leave a voicemail, or is that not safe? So those sort of check-in things can be very important. Also, offering counseling and offering referrals to other places. Sometimes I'll find that clients are afraid to leave that abusive situation because they don't know where they're going to go. And they think that there's no escape, really. They are financially tied to their abuser. They're worried about their kids. They don't know where they're going to go. So saying, you know, there are resources for custody and there are resources for divorce if you want to use them. Where would you like these? Can I email them to you? So offering those things, I've seen lead to an improvement in that individual client situation. But yeah, that's a great question, and I think it really stresses the importance of that safety check. So I do want to respect everyone's time. I have gone over now, so I'll just sort of skip over some of these things. I do want to mention that if you do file an adjustment of status, there will be an interview, and we're also happy to help prepare you for the interview. And that interview is going to focus on the I-485, the adjustment of status application, and not on the abuse suffered by the client. So we're happy to prepare you for that. Definitely let us know if you get any of this information. While the case is pending, remember to keep in touch with us, keep in touch with your clients, in case they change their address or change their phone number. And again, that safety check question, right? Are they still in a safe place? Has their abuser been trying to contact them or stealing their mail or something like that? We're not going to have time for sample cases, but you can have a look at these resources later as well. So these are just some phone numbers, domestic violence helpline, and we have a ton of resources that we're more than happy to share with you. So thank you so much for attending the training. The next steps are you'll begin to receive our email newsletter. Feel free to look at our case list online or via that newsletter, or contact us directly for a case. Tricia provides comprehensive case review, and I handle case assignments. So thank you so much for being with us today. I do want to mention, if you do need CLE, I have the CLE certificate for your records here. Please remember to fill out the this evaluation that you should have with your packets, and I'll collect those as I hand out the CLE. Thanks, everyone.
We can stick around for questions if you didn't get a chance to ask your questions. We just want to make sure you can all get out on time.
Definitely.
Thank you all very much.
Thank you so much.
And thank you to Winston for hosting.
Yeah, we very much appreciate it.